Please get ready for dictation of part 2 of the Virabhai Karshanbhai Vankar versus State of Gujarat. It's a case from Gujarat High Court, and the judgment was delivered on 10th November 2023. 5 seconds. It was held that the entitlement to receive increment therefore crystallizes when the government servant completes requisite length of service with good conduct and becomes payable on the succeeding day. It was further held that the word accrue should be understood liberally and would mean payable on the succeeding day. Any contrary view would lead to arbitrariness and unreasonableness, and denying a government servant legitimate one annual increment, though he is entitled to that for rendering the services over a year with good behavior and efficiently, and therefore such a narrow interpretation should be avoided. He further submits that the division bench of this court, relying upon the judgment of the Honorable Supreme Court, has dismissed the said letters patent appeals involving the same issue. Per contra, learned assistant government pleader submits that in view of the decision in the case of Takhat Sin, the state government had implemented the decision of this court and the special civil application came to be dismissed, keeping the question of law open. He does not dispute that thereafter the Honorable Supreme Court has since settled the issue and held that the government servant is entitled to one increment after his retirement, and that the learned division bench has also dismissed the letters patent appeals involving the same issue. Heard learned advocates for the respective parties and perused the documents on record. Now, so far as the submission on behalf of the appellants that the annual increment is in the form of incentive and to encourage an employee to perform well, and therefore, once he is not in service, there is no question of grant of annual increment is concerned, the aforesaid has no substance. In a given case, it may happen that the employee earns the increment 3 days before his date of superannuation, and therefore, even according to the regulation 41, increment is accrued on the next day. In that case also, such an employee would not have 1 year service thereafter. It is to be noted that increment is earned on 1 year past service rendered in a time scale. Therefore, the aforesaid submission is not to be accepted. Now, so far as the submission on behalf of the appellants, that as the increment has accrued on the next day on which it is earned, and therefore even in a case where an employee has earned the increment 1 day prior to his retirement, but he is not in service the day on which the increment is accrued, is concerned, while considering the aforesaid issue, the object and purpose of grant of annual increment is required to be considered. A government servant is granted the annual increment on the basis of his good conduct while rendering 1 year service. Increments are given annually to officers with good conduct unless such increments are withheld as a measure of punishment or linked with efficiency. Therefore, the increment is earned for rendering service with good conduct in a year specified period. Therefore, the moment a government servant has rendered service for a specified period with good conduct in a time scale, he is entitled to the annual increment, and it can be said that he has earned the annual increment for rendering the specified period of service with good conduct. Therefore, as such, he is entitled to the benefit of the annual increment on the eventuality of having served for a specified period 1 year with good conduct efficiently. Merely because the government servant has retired on the very next day, how can he be denied the annual increment which he has earned and or is entitled to for rendering the service with good conduct and efficiently in the preceding 1 year? Stop.